Hey, thanks for checking out The Persuasive Lawyer. I'm Brendan Lupetin, and my partner Greg and I were recently able to get a fantastic verdict of $10.83 million for this amazing family and their son who suffered a massive brain injury. And it's just awesome because this family truly needs this money to be able to properly take care of their son. But after the verdict, a lot of people asked me about my opening statement. And the thing with my openings and my preparation for trial is that I always record my opening statements repeatedly. And the reason that I do that is because I then take them, I listen to them in the car, and I watch them to figure out ways that I can improve it. Then I go back and I film another opening and try to get it better and better and better. So I am going to show you in just a second basically the opening statement that I did at trial. I think my one at trial was even more polished and a little sharper than this one. You'll see that the video I'm going to show you is still very rough around the edges, and there was a lot of work to do, which I tried to do. I want to just point out a couple big picture things that I think are super important about my preparation for the opening statement in this case. Number one is you'll see that I did it with the mask on. And that was intentional because I knew at trial, given that this was a pandemic opening statement, I was going to have to do my opening with a mask on. So why not practice like you're going to have to do it in real life? So that's the reason why I'm wearing the mask during my recorded opening statement. And I think it's super important because you get used to how it feels, how to talk through it, how to just get used to it. So I think it's important to try to simulate as close as possible the reality of the presentation as you can ahead of time. Number two, I do my opening statement over and over and over again because I find that opening statement is the most stressful part of a trial. You haven't gotten started yet. The spotlight really hasn't been put on you yet. And the opening is your first opportunity when the spotlight turns on and it's all you and all those different fears and concerns are running through your head. What if I forget what I'm supposed to say? What if I don't say it right? What if I flub things up? What if a million different things happen? What if my PowerPoint doesn't work? And so because you have so much stress that inevitably goes away once the opening's done. Once you get into trial, it's like all the stress just dissipates and you're in it and you're flowing, and I don't feel any stress for the most part anymore until jury deliberations. But boy, before opening is it stressful. And so it is so helpful to practice until your opening is second nature. You could do it in your sleep. You're that comfortable with it. So a couple of things I want to point out, my influences of my opening statement. So as anybody that watches this channel or knows me, you know that I'm a junkie for trial technique, trial strategy, psychology, etc. And I'm trying to always read every book and watch every webinar. So this opening statement is not specifically, one superstar lawyer's outline versus another. It's influenced by a number of different people. But the overall big picture part of the outline, this particular opening that I did is most influenced by Don Keenan and David Ball, starting with damages, then goes into the, what the reptile was teaching and now what a lot of the edge is teaching. And again, it is not the most cutting edge stuff that David Ball or Don Keenan is talking about right now. It's still probably a little archaic, but it works for me. I also, you'll see, incorporate Keith Mitnik's putting things in context because for me, that is the best way to undermine the defense arguments. And then I'm also keeping in mind Nick Rowley's recommendation to undersell or understate your opening, because we have that tendency, we want to bowl the jury over and tell them every different shred of important information. And of course, I always try to channel my inner Rick Friedman for just that mental state about how to think about trying a jury and your own sort of level of emotional state that you want to be in, so that you're not too off the charts aggressive or just out of control, that you're trying to be matter of fact, you're just trying to tell this story, and you're trying to be a reliable and credible source of information, because that is so important in these cases. There are big picture concepts that I think should be tried to apply to any opening statement. And the two big ones I think that we always need to strive to incorporate into our openings is, well, actually maybe three. One is you have to have a good story. Okay, so you have to figure out what is the best way to tell the story in this case. And that's figuring out where in time do I tell the story? How do I tell the story? From whose perspective do I want to tell the story? But story in general is so important to sort of set the framework in the jury's minds of what really happened. You know, you're showing them the movie from your vantage point that you're hoping kind of stays in their head to assist you and give you the benefit of confirmation thinking or confirmation bias. The other thing is the focusing illusion. So when you're talking about liability in your opening statement, you want to focus on the actions of the defendants. You don't really want to mix in either irrelevant people in the story or your client, at least in the liability portion of it. You want all of the focus and all of the thinking about why this went wrong on the key defendant players. And so you'll see in my opening, it's focused all on the hospital and the defendant doctor. The last, I think, great point that I heard somebody talk about on one of the trial school seminars recently was, in your opening, you need to show what the defendants did versus what they should have done, and then what difference it would have made. So in the kind of traditional Ball Keenan outline, after your story, you go into who we're suing and why. And it's in that part of your opening that you need to show that the rule or the standard required the defendants to do this very simple thing over here, but they violated it and they did this over here. And had they just done the simple thing that they were supposed to do, it would have made this difference. This is how things would have been different, and this is how easy this would have been to have prevented any of this from happening. So those are just some basic takeaways of my thinking in lead up to this opening statement, and I hope you enjoy it and you get some benefit out of it. Thanks. May it please the court, counsel, ladies and gentlemen of the jury, what brings us all to the courthouse is a safety rule that protects patients from serious injury in the hospital. But like any rule, the safety rule only protects patients if, when it's violated, jurors like all of you choose to enforce the rule. This is the safety rule in this case. Hospitals and doctors must follow their policies and procedures to ensure patient safety. Now, one of the questions that you'll have to consider during the course of this trial is, if the safety rule is violated, and as a result, a patient is seriously injured, who is responsible for all of the harms and losses? So let me tell you the story of what happened in this case. It starts back in the fall of 2015. It's November of 2015. And we're at Tyrone Hospital. And Tyrone Hospital has just installed, in this room right here, a permanent MRI scanner. They had a CT, they had an X-ray, and now they've added to their hospital an MRI scanner for their patients. As part of the installation of the new MRI scanner, the hospital has in place 2 patient safety policies. There's an emergency drug box policy, and there's an MRI alarm policy. The drug box policy says that in any room in the hospital where diagnostic contrast agents will be injected into patients, there must be available in the room a drug box containing medicine to treat allergic reactions to the contrast media. I'm sure many of you are very familiar with MRI scans. Maybe you've had them, maybe you know people that have had them. And so you know that many MRI scans are performed by injecting material, chemicals, into the patient's body, which enhances the imaging for the radiologist. Now, that is called gadolinium. And it's well known that gadolinium, though safe, carries with it a risk in some patients of causing severe, life-threatening allergic reactions. And as a result, the policy says that the medicine will be right there in the room to treat those reactions if they happen at Tyrone Hospital. The MRI Alarm Policy has to do with a button that's installed in the MRI suite, and it's on a wall. And the button is set up that if an MRI technician needs immediate help with a patient in the MRI room, the technician can hit the button, an alarm sounds in the emergency department, and an emergency room doctor and a nurse immediately come down to help treat the patient. Now, this is really important because at Tyrone Hospital, number one, the MRI technicians are in the room with the patient by themselves. Okay, they do them by themselves. There aren't other medical providers with them. And number two, the MRI technicians, though they're allowed to administer the gadolinium chemical into the patient, they are not allowed to treat the patient if an allergic reaction happens. Instead, they have to call for help, and so the emergency room doctor or healthcare staff comes down and they treat the patient. So those are the two policies that are in place when the MR scanner is put in at Tyrone Hospital. So we fast forward just a little bit, and just before patients are about to start coming in, Tyrone Hospital has an employee. She's an MRI technician, and her name is Sherry Piper. Sherry is a seasoned radiology technician. She is a certified MRI technician, and she's worked at many hospitals and has a lot of experience with MRI scanners. Sherry Piper walks into the new MRI room at Tyrone Hospital, and she notices something. Something's missing. Sherry Piper sees that the MRI room at Tyrone Hospital does not have an emergency drug box in it. So Sherry Piper goes and asks the manager of the radiology department, hey, where's the drug box? And she's told, we've decided it's not necessary because that medicine is down in the emergency department. And that's how things stay at Tyrone Hospital for the next year. And they start to see patients, and patients come in for their MRI contrast studies, and there is no drug box in the room. And so we fast forward now to October 4th, 2016. It's a Tuesday, and we're back at Tyrone Hospital. And now we're inside the MRI room at Tyrone. And Sherry Piper's in there, and she's with a patient who's come in because he has lower back pain, and his doctor has prescribed him an MRI to find out what's going on with his lower back. So Sherry sees that the patient's been in the scanner for the past half an hour for a non-contrast MRI. Everything's gone just fine, no problems whatsoever. But now it's time to do the contrast study. So Sherry goes in, she pulls the patient out of the scanner, his head's down here, his feet are down here, he's covered by a blanket, and his face is peeking out right here. She takes the patient's right arm, she inserts a needle into the arm, and attached she has a syringe full of 20 milliliters of that chemical called gadolinium. Sherry begins to inject the gadolinium into the patient, and she barely gets halfway into the injection and she has to stop because something suddenly happens to the patient. Sherry sees that all of a sudden the patient's face has turned red. She hears the patient saying that he wants to sit up, he needs to sit up. She sees the patient start moving so much that the IV actually comes out of his arm. Sherry, not a doctor, is not sure exactly what's going on, but she's concerned the patient's having one of those life-threatening allergic reactions to the contrast medium. So Sherry tells the patient, lay there, stay where you are. And Sherry leaves the room, and I'll show you a map now. So she's right here, and this is where the patient is with the MRI. She leaves the room and runs into her little computer room, and she hits the button on the wall to sound the alarm. So she hits it, and she's signaling she wants emergency personnel to come down and help treat the patient immediately. But nothing happens. So Sherry goes out this door, and then she screams into the hallway, I need help, get help, get a doctor. Now, there's a little conflicting testimony here. Sherry says she screams and somebody else must get the head of radiology, Dr. Biggs, who's down here in his office reading scans. Dr. Biggs remembers that Sherry actually comes all the way down the hallway and gets him in his office. Either way, Dr. Biggs is notified that the patient needs help in the MRI room. So Dr. Biggs walks down the hallway through this door, through this door, through this door, and he sees the patient laying on the MRI table. And Dr. Biggs does not perform any evaluation of the patient whatsoever other than trying to talk to the patient. And the patient is not responding to him. In fact, Dr. Biggs is concerned that the patient actually might be unconscious at this point. Dr. Biggs thinks that he can see the patient's chest moving, indicating that the patient's breathing. So what does Dr. Biggs do? He leaves the room. And Dr. Biggs walks out of the MRI and he decides to head down to the emergency department because no emergency personnel has responded yet to the alarm. So Dr. Biggs decides to go get the emergency personnel himself. And where he's trying to get is right here. Okay, this is the computer station area where the emergency room doctors work when they're not treating patients. And Dr. Biggs is looking for a particular emergency room doctor, Dr. Zanoble. He's the head of the emergency room at Tyrone Hospital. So Dr. Biggs eventually makes his way down to the computer area where Dr. Zanoble is expected to be working. And Dr. Biggs is expecting to find Dr. Zanoble sitting at his computer station working. But instead of sitting, Dr. Biggs finds something different. Dr. Zanoble is actually standing on his chair when Dr. Biggs gets there. And Dr. Zanoble is not just standing on his chair, he's actually doing something with the ceiling. He's lifted up one of the drop tiles of the false ceiling. And Dr. Zanoble has his head inside the ceiling and he's looking for something. You see, there's this sound that's been going off. And Dr. Zanoble doesn't know what it is, and he's trying to figure out where it's coming from. When Dr. Biggs arrives and says, I need your help down here with the patient in the MRI room. So now, Dr. Zanoble gets down off of his chair, and he walks down the hallways of the hospital, comes through these doors, and gets inside. And he finds the patient on the MRI table still. And Dr. Zanoble goes and takes the patient's pulse. The patient still has a pulse, but the patient is not responding appropriately to him either. So Dr. Zanoble realizes this patient, we've got to get him down to the emergency room right away. And he starts organizing people, get this patient ready. And so finally the patient is taken off of the MRI scanner and put onto a gurney and then taken out of the MRI down this hallway, into emergency room 3, where they keep the medicine to treat conditions like what the patient has. But when they get the patient there finally, and they begin to first evaluate him, the staff realizes that the patient no longer has a pulse. And the staff realizes that the patient's heart has stopped. So now for the first time, a code is called. It's all hands on deck. People come in, a full-blown resuscitation takes place for the next 35 minutes. And eventually the patient's heart is restarted. But unfortunately, because of how long the patient's gone with improper circulation through his body, in particular, a lack of blood and oxygen to his brain, the patient has suffered a massive and permanent anoxic brain injury. The patient at the time is 41 years old. He's a project manager for a telecommunications company. And he's a father of 3 daughters. And his name is Chris Miller. And my partner Greg and I represent Chris Miller and his dad, who's his guardian, in this lawsuit against Tyrone Hospital and Dr. Kelly Biggs. So let me tell you why we're suing the hospital and Dr. Biggs. We're suing them because they violated the patient safety rule that says you have to follow your own policies and procedures. We're suing them because they violated the drug box policy and they violated the MRI alarm policy. Dr. Biggs was the director of radiology. He was responsible for making sure that everybody was trained and knowledgeable on what to do with respect to these policies. And these were the hospital's policies. And we're going to show you that they were violated. we're going to bring you testimony from Miss Piper. And when I say I know what they're going to say, we've already taken their depositions under oath. So they've already told us all this information. Miss Biggs is going to tell you, Miss Piper is going to tell you that she brought this up a year beforehand. Why isn't there a drug box policy in here? Because she knew of the risk of these allergic reactions. And she was told that the hospital made a decision just not to keep one in the MRI room because the medicine was close enough down in the emergency department. And so that medicine was not available to give to the patient, like an EpiPen, because it's epinephrine that's in the drug box that we all know is what you use to treat allergic reactions. Wasn't available for anybody to give to Chris Miller at the time that he needed it most. And we're also going to bring you testimony and show you that Dr. Zanoble had no clue about this MRI policy, and it wasn't his fault. Dr. Zanoble is a doctor. He's a smart, intelligent person. And we'll know just by his very response that the alarm, though it was working and he heard it going off, and he probably figured out that that thing that he was looking for, that was the alarm going off, that he was doing that and he had no idea what it meant or what it signified he was supposed to do because he had not been trained about it and thus could not follow that policy. And you'll hear that there were other nurses in the hospital that were unaware that the policy said if that alarm goes off, it means immediate help's needed in the MRI. And why this is all significant is because it wasted time that Chris Miller did not have. It caused needless delay in providing Chris evaluation and treatment of his serious allergic reaction called anaphylaxis that he was suffering from at the time. Had the policies just been followed, so what should have happened? The policies are followed. Well, when the alarm gets hit, an emergency room doctor, Dr. Zanoble, gets down there right away, maybe 30 seconds. And if needed, he can immediately administer the epinephrine to the patient because it's immediately available, or he can arrange to quickly get the patient down to that emergency room 3 where they can fully evaluate the patient, provide him the treatment he needs before his anaphylaxis causes his heart to stop. But that didn't happen because policies weren't followed. Now, if you remember one thing from this opening statement, remember this, that Chris Miller went to the hospital entirely fine for a routine MRI study, has an allergic reaction in a hospital, and is allowed to progress into full-blown cardiac arrest where his heart has stopped without getting any medical treatment in between, without getting any medicine administered to him to prevent the cardiac arrest in between. The only medical care, if you want to call it care, that Chris Miller got in that period of time from the start of his symptoms to his full-blown cardiac arrest was Dr. Zanoble taking his pulse. That was it. So I'm sure all of you feel that in life, it's never good for things to be taken out of context. And it's super important for things that we learn about and talk about always to be put in proper context. Well, in court, when we're talking about a serious matter like this, it's doubly important that things be put in proper context. So in a few minutes, I'm going to sit down and defense counsel Sosnowski, who is a very good lawyer and a very nice guy, is going to get up and he gets to respond to everything I'm saying right now. But when he's done, I don't get to respond to what he said. I'll have to wait to talk to all of you again like this until the very end of the trial in closing argument. And because I don't get to respond to what Attorney Mike is going to say in response to me, I'll do it now. So let me discuss with you what I believe are the 3 excuses that the hospital is going to use to explain why they shouldn't be at fault for what happened to Chris Miller. And they break down to, it was a rare event, it happened fast, and they needed more time. So let's deal with those one at a time. So they're going to say that this is a very rare event. And fortunately, they were right. That's true. Okay, these do not happen very frequently. They happen like a fraction of a percentage point, okay? But because 37 million MRIs are done every year, it's well known in the medical industry that these reactions can occur and do occur. And because of their severity and how life-threatening they are to patients, everybody has to prepare accordingly. In fact, they're so well known that the manufacturer of that gadolinium chemical actually warns right in their package insert about these reactions, that they can occur and that hospitals need to be prepared to immediately respond and treat the patient if and when they do occur. So the next argument is that this happened really fast. Okay, so the hospital is going to tell you that from the time Chris was injected with the gadolinium until he's in full-blown cardiac arrest, and everything I described to you that happened in between, they're going to tell you that that happened in less than 5 minutes. And it's going to be up for all of you to decide if that timeline, based on the evidence you hear, matches up. But putting that aside, okay, and putting this argument in context about how fast that this happened, and one other point that's critical here. They're going to talk to you about how Chris was being prescribed oxycodone and that Chris was a heavier guy. And so that made this reaction happen even faster, that accelerated the time to his cardiac arrest even faster. Well, we're going to bring you a medical specialist in emergency medicine who's also a specialist in what's called pharmacokinetics, which means drug interactions within the body. And he's going to explain to you that Chris's size and his prescribed medications had no effect on speeding up his cardiac arrest. But nevertheless, let's assume and put in context the fact that this did happen quickly. And let's just assume that the prescribed medication that he was taking and his size did accelerate things. Well, the hospital knew or should have known about that ahead of time, before the MRI was even done, and they, if it was significant and important, should have prepared accordingly. Chris's doctor, who prescribed him the medication that he was taking according to doctor's orders, was part of the Tyrone network. So it should have been readily available to the hospital that Chris was in fact being prescribed oxycodone at the time. And obviously, if Chris is visibly large, you plan accordingly if it's significant that he's a bigger guy. And the key here, though, is if there's less time, and this happens so fast, that just underscores the fact that there's less time to waste, and it stresses the importance of policy and preparing ahead of time so that you're prepared. You run mock drills, fire drills, if you will, of what are we going to do if a patient has one of these reactions. Everybody's going to be trained, everybody's going to know how to follow the policies so that time is not wasted when things happen fast, which is always the case in an emergency. And finally, they're going to say we needed more time. They're going to tell you that the location of this was really unfortunate because it was in the MRI room, and that's a bad place to treat patients because the MRI is a big magnet. And they're going to tell you that before they could give any medicines, they had to perform a full evaluation of Chris to make sure that this was in fact an anaphylactic reaction, because maybe it wasn't. Okay, what if it was something else? We don't want to give him medicines that could be problematic for him. Well, first and foremost, you're going to hear that if there is a suspicion that a patient is having an anaphylactic reaction, an allergic reaction like this, which is life-threatening, there are no contraindications to giving the patient epinephrine. You give the patient epinephrine because of how dangerous that condition may be. You're going to see that this was textbook anaphylaxis, and we're not doing after-the-fact analysis. We're going to provide you the facts that we know from the witnesses and the medical records, which are everybody knows gadolinium can cause these reactions, and it had just been administered to the patient when he suddenly has a reaction to it. That this was sudden, it was fast, it was an immediate response to the allergen being injected into his body. You're going to hear that Chris had a red face, which is a classic sign of an allergic response, that he started feeling hot. You're going to hear that he sat up, became agitated, feeling anxious, another clear sign of anaphylaxis. You're going to hear from the risk manager of the hospital that everybody was talking about the fact that Chris was complaining of being short of breath, yet another textbook sign of anaphylaxis. And finally, you're going to hear that when Dr. Biggs and Dr. Zanoble get into the room, Chris has now having mental aspects. He can't respond appropriately. Dr. Biggs thinks he actually may be unconscious at that period of time, which would be a classic progression of an anaphylactic reaction occurring over time that, if it's not treated in time, is going to lead to cardiac arrest. You're going to see that there was time to give epinephrine if the epinephrine was immediately available. Okay, there was time to determine this patient, more likely than not, has anaphylaxis. Let's give him the epinephrine. But even if that, you put that aside and you say we have to get him fully out of the MRI room and down to the emergency room, if the policy is followed and time is not delayed, there's ample time to get the patient down to the emergency room where he can be evaluated, where he can be treated before the arrest happens. Now, as jurors in this case, you're going to have three big jobs. Your three jobs are deciding negligence, deciding causation, and deciding damages. Negligence, as you look at the facts of this case, is just, was the hospital and the doctors as careful as they should have been? By not following policies, was that as careful as they should have been under the circumstances? And you've just seen a lot of the evidence that's going to come into this case to explain why they were negligent. And one point I want to make on this is that in regards to the standard of care you'll hear about, okay, that's what people are judged by, okay, the medical standard of care. What were the medical standards at the time? We are not trying to hold the hospital to some heightened standard. We're not saying, oh, you should be like a UPMC or a Geisinger or one of these big giant hospital systems and do what they do there. We're not doing that. All this case is about is we are suggesting that the hospital simply follow the policies that it had in place. It calls them their standards of practice. We're just saying follow your policies and procedures, and none of this would have happened. Your policies and procedures are adequate. Just follow the ones that you have in place. As for causation, okay, that is, did the actions or inactions of the hospital contribute to Chris's brain injury, his cardiac arrest, the lack of treatment of his anaphylactic reaction? Well, keep in mind, it was the hospital that injected Chris with the gadolinium. It was the hospital that knew about the risks of these serious allergic reactions, and it was the hospital that knew to be prepared and ready to treat those allergic reactions in time when they happen, even if they are rare. And you're going to see that Chris did not get any medical treatment, no medicine injected into him before his heart stopped. And that is why the inactions of the hospital and the delays and the violations of the policies caused or contributed to his brain injury. And finally, you have to assess, through all the different evidence, the amount of money, the financial harm caused as a result of Chris's allergic reaction not being treated in time and the brain injury he suffered and everything that he lost and was taken from him as a result. Now, because we have a job ourselves to prove our case to you, we have to bring you a bunch of witnesses, a lot of whom are going to talk about who Chris was before, because none of us knew Chris before, so we need to learn about who he was, what he was up to, what kind of things he was doing, and we have to also provide you testimony about what he's like now as a result of his brain injury. I'm going to tell you right now, some of it is pretty sad. But I want you to know that we are not bringing you this testimony so that you feel bad for Chris, that you have sympathy for him, okay? Because A, sympathy doesn't do any good for Chris or his family, okay? And more importantly, there's no place for sympathy in a court of law. There is not. It is, you can feel it, but you cannot let sympathy affect your judgment or consideration of Chris. And just as importantly, you can't let any sympathy you might have for the hospital or for Dr. Biggs affect your evaluation of the case entirely. So let me tell you a little bit about some of the evidence we'll show you as far as the damages are concerned. So with respect to Chris before, this is Chris right here, okay? And this is a picture with his brothers and sister taken about 2 or 3 days before this whole event happened. That's 2 or 3 days before the event happened. Now this picture's from several years ago, but it's Chris with his 3 daughters out at a baseball game. And what you're going to learn from these different witnesses is that Chris was a beloved father, son, and brother. You're going to hear that he had a great job, was killing it as a project manager for a company called Expert Communications, which was a telecommunications company that has been growing and doing really well, and that Chris was a rising star within the company. You're going to hear from his boss, the owner of the company, his name is Kevin McCarthy, will tell you what an asset Chris was and what a loss it has been for the company to not have Chris there anymore because of his brain injury prevents him from working anymore. And you're going to hear that Chris was a really intelligent guy, a smart guy, one of these people that never had to crack a book and would just pick up concepts quickly and be able to apply them. And he would always be able to do that throughout life. and that he was the calm and collected one in the family, the one that his siblings, that his parents, that everybody could go to for counsel, for advice, for insight. You know, what wisdom is what he provided to his family and his friends. He was the keystone of their family. He was the guy that set up and coordinated all the parties. He would arrange for the family to go to Steelers training camp and things like that. So Chris did a lot, and he was beloved by his daughters. Now, we're going to bring you testimony of two neuro specialists, and Dr. Wiegers and Dr. Thomas Franz. They're going to explain to you the massiveness of this brain injury and how this lack of circulation and lack of oxygen from the arrest and during the resuscitation process caused what's called diffuse, meaning total brain injury, all aspects of the brain injured, but in particular, frontal lobe and temporal lobe, which affects Chris's ability, it affects his memory, and it affects his impulse control, and it affects his behavioral control. And you're going to see how Chris is now, with pretty much everybody, you'll see this consistent theme refers to, he's like a kid. He's a big guy, but he's like a kid in regards to his impulsivity, his lack of an inner voice telling him right and wrong, safe, not safe. He has no memory anymore. His short-term memory, I don't know if you ever saw that movie Memento, where the guy loses his short-term memory and has to tattoo what he did minutes ago on him so he doesn't forget. That's Chris, sans the tattoos, okay? 2 minutes after he's done something, he forgets it. And that's a real problem you're going to hear, because it makes him dangerous to himself and dangerous to others. Because, for instance, if he goes down to cook an omelet in the house and he fires up the stove, he'll forget about it in a couple of minutes. He'll lose interest, he'll get distracted and go leave, and he'll leave the burner on. He could burn the whole house down with himself and other people in it. That's just one example you hear about of why Chris is so unsafe now. You'll hear about his perpetual behavior and emotional outbursts that make him very unpredictable, even scary at times, even though he recognizes this and he gets extremely emotional. He'll be crying 1 minute and yelling and screaming the next minute. And you're going to hear from his caretaker, because his injury and his deficits are so significant now, he has to have a daily caretaker, a really sweet guy named Matt Sharp, who spends 7 a.m. to 3 p.m. every day with Chris, taking him out, being with him, watching out for him, making sure that Chris doesn't get into trouble or injure himself. And then the rest of the time you're going to hear from them, Chris has to be watched by his not very young anymore parents, Sharon and Tim. And they have to watch him at night, and they have to watch him on the weekends. And you're going to hear what a monumental task it is to keep Chris safe and to keep others safe from Chris. So there are two types of damages that are recoverable in Pennsylvania. There are economic damages and there are non-economic damages. The economic damages in the case are medical bills, past and future, and then also earnings past and future. So Chris has more than $300,000 in past medical bills that have resulted from this. He has past lost earnings. We have consulted with an economist who is a professor at Duquesne, Dr. Matt Marland, who has calculated what Chris's past lost earnings are, as well as what his future lost earnings will most likely be, factoring in the different interest rates and depreciation and things of that nature. And then we've hired Heidi Fauber, who is a certified life care planner, and what she does is take all the doctors' opinions about the care that Chris is going to need into the future, and then she goes out and figures out how much that care costs and then multiplies it by Chris's life expectancy, which is set by actuarial tables under the law. And you'll see that those numbers are very significant in the many, many millions of dollars. Now over here, you've noticed these parentheses. Well, the defense has hired their own accountant who has gone and looked at the numbers of our consultants, and doesn't say that they're nothing, that there's no damages. He just comes up with his own way of making the numbers less. But you can see that even the defense accountant agrees that Chris's future losses are very, very significant and in the many, many millions of dollars. And finally, throughout this case, the reason we have to bring all that evidence, these different people telling you stuff, is because the law allows Chris and recognizes that people with injuries like Chris are entitled to be compensated for their losses that relate to all of these type of things, okay? But the main one in this case, I really believe, there's definitely distress and embarrassment and mental anguish, and you'll hear different anecdotes about all that stuff. But the big one is loss of the pleasures of life. Because as all of us know, our Bill of Rights as Americans is life, liberty, and the pursuit of happiness. And you'll really see that Chris's ability to do those things, to have a life, to be free, and to pursue life's pleasures has been destroyed. And he doesn't really have it anymore. He doesn't have an interest in doing the things that he used to love to do, like hunting and fishing. He loved his job, okay? He can't do it anymore, okay? He just loses interest in everything very quickly. He has to just watch movies, basically the same ones, over and over and over again, because for him, it's Groundhog Day. And his interest in anything wanes and dissipates very quickly after he begins it. And so you're going to see that those are the biggest harms in this case. While there's millions of dollars up here in the hard numbers, I believe that at the end of the day, the evidence will show that these losses dwarf those. And that's going to be the reason why the evidence at the end of the case is going to justify all of you rendering a very, very significant and large verdict in this case. Now, before I sit down, I just want to tell you that my partner and I have worked really hard to compress and condense and distill down all of the mountain of evidence that has been developed in this case over the last several years to pare it down to just the information that you need to make your decision, okay? And because you're making a huge sacrifice to be here. We recognize that, we appreciate that, and we don't want to waste your time. So we're going to try to be as quick as we can. We have a lot of witnesses on videotape, to minimize the pandemic issues and also be able to speed things up so that there's never a dull moment when we're presenting our case to you. We're going to hope to have our case at least done to you by Thursday morning so that you can get to your job of making this big decision and get back to your lives as soon as possible. And we think, again, that at the end of the day, you're going to see why this justifies a very significant verdict in favor of Chris Miller. Thank you.